On September 12, 2022, Hindu groups cheered and celebrated in the spiritual capital of India after the Varanasi court delivered its ruling on the Kashi Vishwanath-Gyanvapi dispute case.
आज पूरा भारत खुश है। आज हम भारत को यही एक सारे ब्रह्मांड में वो करना चाहते हैं। सबसे विनती है जितने हमारे हिंदू भाई बहन हैं आज अपने घरों में घी के दीपक जलाए, शंख नगाड़े बजाए और हर हर महादेव का नारा लगाए।
The Varanasi District Court rejected the Muslim Committee's plea challenging the maintainability of the suit filed by 5 Hindu women. 5 Hindu women had filed a plea seeking worshipping rights in the Gyanvapi Mosque compound. The district judge said that the court would continue to hear the petitions seeking the right to worship. The petitioners were also seeking an ASI survey and carbon dating of Shivling found inside the mosque complex.
अगला स्टेप ये है कि जो एसआई सर्वे की मांग है वो हम करेंगे, शिवलिंग की कार्बन डेटिंग की मांग करेंगे, जो शिवलिंग के नीचे उसका अर्घा है उसको ढूंढने का एक और कमीशन जारी कराने की मांग करेंगे और साथ ही साथ सबसे महत्वपूर्ण जो कमीशन की रिपोर्ट है उसको कोर्ट के रिकॉर्ड को फाइनल पार्ट बनाने का काम करेंगे।
The Hindu side feels the ruins of old temples found at the walls outside the barricading and Hindu motifs in mosque premises found in the video survey bolster their case. AIMIM chief Asauddin Owaisi has, however, warned that the Varanasi district court's order will have a destabilizing effect and create problems in the country.
हर जगह पर एक डिस्टेबलाइजिंग इफेक्ट पैदा हो जाएगा। तो ये हम तो उम्मीद कर रहे थे कि कोर्ट इस तरह के इश्यूज को जैसे अंग्रेजी में कहते हैं कि दे विल निप इट इन इट्स बट, मगर अब लगता है कि इस तरह का लिटिगेशन अगर आगे बढ़ेगा तो फिर ये उसी रास्ते पर जा रहा है जो बाबरी मस्जिद का लीगल इशू गया था।
The most significant argument made by the Mosque Committee's side was that the suit is barred under the Places of Worship Act 1991. So, what is the Places of Worship Act? It is an act to prohibit conversion of any place of worship as it existed on the 15th day of August 1947. Section 3 of the Act bars the conversion in full or part of a place of worship. However, District Judge A.K. Vishwesha ruled that the suit is not barred by the Places of Worship Act 1991. Notably, the Varanasi court said that the Muslim side's argument does not hold much water because the plaintiffs want only the right to worship at the disputed property and are not claiming any ownership over the mosque. Places of Worship Act prohibits the conversion of places of worship such as churches, mosques and temples. However, Ram Janmabhoomi Babri Masjid dispute was an exception under the law. While the Muslim side pinned hope on the act, several petitions challenging the constitutional validity of the law are pending before the Supreme Court. BJP leaders Ashwini Upadhyay and Subramaniam Swamy are among those who have filed petitions challenging the law. The Supreme Court listed the petitions for October 11th and directed the centre to file a response in 2 weeks. However, as the top court hasn't issued any stay on the trials under the Places of Worship Act 1991, all matters including Gyanvapi will be heard in courts across the country. While the All India Muslim Personal Law Board said that the Varanasi court's order in the Gyanvapi Shringar Gauri dispute is very disappointing and painful, for now the district court will decide on the plea filed by the plaintiffs. That is, whether they have a right to pray inside the mosque. Now the focus has also shifted to Shri Krishna Janmabhoomi Shahi Eidgah Mosque dispute. The Hindu Mahasabha on September 13th filed a petition in the Mathura Civil Court seeking the removal of the Meena Masjid in the city, claiming it was constructed on the land of the Shri Krishna Janmabhoomi complex. No matter what Owaisi feels about the Varanasi court's order, the case highlights the multi-layered complexities of Mandir Masjid dispute, which might not necessarily fall under the Worship Act. Only time will tell if Gyanvapi case will set a precedent for such religious legal battles in future.